An S-Corp or an LLC can both be useful options for a Creek County business owner, but they are not the same thing. The right choice depends on your business structure, ownership, income, payroll, liability concerns, tax goals, record-keeping habits, and long-term plans. Before choosing, you should understand what each option does and how the decision may affect your business. What is an LLC? An LLC, or limited liability company, is a flexible business entity and is common among small businesses. The owners are members. An LLC may have one owner or multiple owners. Management may fall under the members themselves or by appointed managers. Many Creek County business owners choose LLCs because they are flexible, relatively simple to operate, and useful for local businesses such as contractors, service companies, real estate businesses, retail stores, family businesses, consulting companies, and small professional operations. An LLC can help separate the owner's personal assets from ordinary business debts and obligations. However, the owner must still treat the LLC as a separate business by maintaining separate bank accounts, keeping records, signing contracts in the company's name, and avoiding the mixing of personal and business funds. What is an S-Corp? An S-Corp is not always a separate type of business entity in the way many people use the term. In many cases, S-Corp refers to a tax election made with the IRS. A corporation may elect S-Corporation tax treatment if it qualifies. In some situations, an LLC may also elect to be taxed as an S-Corporation while remaining an LLC under Oklahoma law. S-Corporation tax treatment may be useful for some profitable businesses because it can affect how income is treated for payroll and self-employment tax purposes. However, the business must follow eligibility rules, payroll requirements, reasonable compensation rules, ownership restrictions, and tax filing requirements. This is why the S-Corp question should usually involve both an attorney and a tax professional. Liability protection. Both an LLC and a corporation taxed as an S-Corp can provide liability protection when properly formed and operated. Liability protection means the owners are generally not personally responsible for ordinary business debts just because they own the company. That protection has limits. Owners may still be personally liable if they personally guarantee a loan, commit fraud, personally injure someone, fail to pay certain taxes, mix personal and business funds, undercapitalize the business, or use the entity improperly. Forming the business is only the first step. You must also operate it correctly. Tax differences matter. The main reason many business owners ask about an S-Corp is taxes. An LLC is often a pass-through entity by default. A single-member LLC is commonly treated as a disregarded entity for federal tax purposes, while a multi-member LLC is often taxed as a partnership unless another election is made. An S-Corp also generally provides pass-through taxation, but it may allow an owner-employee to receive a reasonable salary and potentially receive additional profits as distributions. That structure may reduce certain employment tax exposure in some cases, but only when handled correctly. If the business is not profitable enough, the S-Corp election may not be worth the extra payroll, accounting, and compliance costs. If the business is profitable and the owner actively works in the business, S-Corp treatment may be worth discussing with a CPA. Payroll and reasonable compensation. One major difference is payroll. If an owner works in an S-Corp, the owner generally must be paid reasonable compensation for services provided to the business. That means payroll tax filings, withholding, W-2 reporting, and regular payroll compliance may be necessary. Some small businesses are not ready for that level of structure. If the business is new, inconsistent, seasonal, or not yet profitable, an LLC taxed under the default rules may be simpler. If the business has steady profits, payroll systems, and good bookkeeping, S-Corp treatment may become more practical. Ownership rules. LLCs are usually more flexible in ownership structure. They can often have different classes of economic rights, flexible profit distributions, and customized arrangements among members through an operating agreement. S-corporations have stricter rules. They generally must have eligible shareholders, limited types of ownership, and only one class of stock. These restrictions can create problems if the business wants investors, different distribution rights, business entities as owners, or more complex ownership arrangements. If your Creek County business has multiple owners, family ownership, outside investors, or plans to bring in partners, the ownership structure should be reviewed before choosing S-Corp treatment. Record-keeping and formalities. An LLC usually has fewer formalities than a corporation, but it still needs good records. An LLC should have an operating agreement, separate bank account, ownership records, accounting records, written major decisions, and properly signed contracts. A corporation, including one taxed as an S-Corp, generally involves more formal structure. It may require bylaws, shareholder records, director minutes, officer appointments, stock records, and more formal decision-making. An LLC taxed as an S-Corp may avoid some corporate law formalities, but it still must handle the tax and payroll requirements that come with the S-Corp election. Which is better for a new Creek County business? For many new small businesses, an LLC is often the simpler starting point because it provides flexibility and liability protection without the same level of tax and payroll complexity. The business can focus on operations, customers, contracts, insurance, bookkeeping, and growth. As the business becomes more profitable, the owner may later discuss S-Corp tax treatment with a CPA. This can allow the business to keep the LLC structure while considering whether a tax election makes sense. When an S-Corp may make sense, S-Corp treatment may make sense when the business produces enough consistent profit to justify the added payroll and accounting costs. It may also make sense when the owner actively works in the business has reliable books, and the owner is prepared to pay reasonable compensation. An S-Corp may not make sense if the business has little profit, irregular income, passive ownership, complicated ownership arrangements, or owners who do not want to maintain payroll and tax compliance. Do not ignore the operating agreement if you choose an LLC. The operating agreement is one of the most important documents. It explains ownership percentages, management authority, voting rights, profit distributions, member duties, buyout rights, transfer restrictions, and what happens if an owner dies, leaves, becomes disabled, or disagrees with the other owners. Many business disputes happen because owners form an LLC but never put their agreement in writing. A properly drafted operating agreement can prevent confusion and protect the business. Do not forget contracts, insurance, and licenses. Choosing between an LLC and S-Corp tax treatment is only one part of starting a business. Creek County business owners should also consider contracts, leases, customer terms, employment documents, independent contractor agreements, insurance, local permits, sales tax registration, payroll tax accounts, and bookkeeping systems. A business entity helps reduce risk, but it does not replace good contracts, proper insurance, and careful compliance. Whether your Creek County business should be an S-Corp or an LLC depends on your goals, profits, ownership structure, tax planning, liability concerns, and willingness to maintain records and payroll compliance.